Robbie. Thank you for joining us for our live program that we do every Tuesday, 5 p.m. Pacific time, where I come into your phones and your screens to talk about U.S. immigration, taking your questions live on Instagram, TikTok, Facebook, YouTube, and LinkedIn, where you can ask general questions. I give general educational material about the U.S. immigration process, very complex kind of stuff, very confusing kind of stuff. And so we'll take questions as they come in on these different platforms. Have a lot of fun doing it. And for those watching the live show, we give away free video consultations. So all you got to do is like and subscribe and either ask a good question, or if you don't have a question, maybe write a consultation, and we'll semi-randomly pick somebody. My assistant and I, Katrina, will semi-randomly choose 3 people every 10 minutes. So 3 people to have the free video consultation and talk in private about your case. Also, if you're interested in marriage immigration, fiance visas, I got a guide. It's called the Ultimate Green Card Guide, Ultimate Marriage Green Card Guide. That goes through the whole process, 40 plus pages. Helped a lot of people out. Thousands of people have been helped out by this. I get the emails. All you got to do is download it. Go to marriageimmigrationlaw.com. The website is www.marriageimmigrationlaw.com. And there you can download the guide for yourself, see for yourself the amount of content and information we have there to help you out for free, so you'll enjoy it. Having said that, let's just start the show. So Mama Sadie on regular says, hi, John. Good evening. Good to see you again, Muhammad. And as the question trickling, I do want to mention 2 important things that have popped up in the U.S. immigration system. The first one is for those entering the United States with non-immigrant visas. This could be tourist visas, student visas, work visas, and the like. When you're entering at the airport, you usually get a stamp that says the date you enter and how much time you have on there and the type of visa that you had, as well as the name of the airport will be on the stamp. They are starting to discontinue this program. So there's a pilot program where most major airports like LAX will not stamp your passport when you come in. They'll just look at it and scan it, but they'll let you go. And that creates some problem because some people don't know how much time they have. Because this program started a few months ago, I'm already getting people who don't know how much time they have on their stay, and they assume the amount of time on their, for example, B2 tourist visa that was stamped at the embassies, how much time that they could be in the United States. But that's incorrect. Now you have to go online and use Form I-94. So if you go to Google, you type in Form I-94, you'll go to the Customs and Border Protection website, and you look up your record through the I-94 record by including your passport information on that site. It'll give you a breakdown of when you entered, last visa that you used, how much time you have. So it's very important that you always check this every time you enter the United States, because they could put the wrong visa on there. That could be problematic. For example, if you have a tourist visa and a B tourist visa and an H-1B visa, the officer may mistakenly have you enter as a tourist visa holder instead of a work visa holder. And if you work on a tourist visa, that's a violation. So you don't want to do that. So you want to check that and have it corrected. Or they may give you more or less time than you expected. So you always want to double check that. It's very, very important to do that to avoid problems from happening. And secondly, they're updating Form I-485 adjustment of status application. We're going to do a video on this that breaks down further, but they're going to add some public charge questions, ask about your income, your debts and liabilities, and if you got certain government benefits in the past, as well as your education level, to gauge whether you will be a public charge, which means they'll deny your green card because they're afraid that you're not be able to support yourself in the United States. Most people do not need to be afraid of this. It's just a nominal thing that's happening. Unless you've got money from the government to maintain your income, or you've gotten money from the government for long-term institutional care, those are problematic. But most people are not going to fall within that field, so it's not going to be a problem. So I want to talk about these 2 important changes that are happening this quarter in the U.S. immigration system. There's a lot more stuff popping up, but we got a couple questions we got to get to first, so let's jump to it. Let's take the first question. Secrets asks, hello, I received the I-539 after 2 years, and the approval date is 2020. A lawyer told me that if I leave, I'll get a 10-year bar. So now that lawyer gave you some incorrect information. It depends. I haven't seen your receipt notice and approval notice, so I can't say exactly. But to get what's called a 10-year bar, you have to be in the United States without status for 1 year or more and leave the U.S. The act of leaving triggers a 10-year bar to reentry. So if you want to come back within 10 years, you got to get a waiver. They're just not going to let you in. But you need 1 or more year of unlawful presence. There's a special policy that they have. It's called a period of authorized stay. So it says if you have an application pending, like your I-539, while it's pending, you do not accumulate what are called unlawful presence days. And those unlawful presence days are what you need to accumulate a year's worth of and then leave to trigger the 10-year bar. Since you had if you had the form I-539 pending, you did not accrue unlawful presence days. So even though it was approved, backdated, you should have continue to do tourist visa filings to get later dates, bridge B2. That would have been the appropriate thing to do in this case. But you did it. But that's a side issue. But your worry about being subject to 10-year bar is not correct, because up until the date where you got the decision, even if it was backdated, you were not accruing unlawful presence because you're in a period of authorized stay. You had the form I-539 pending. So it's not appropriate for them to consider that time that you're in the United States as unlawful presence days for the 10-year bar calculation. Now, once you got the approval notice, which had the back date, then that's going to be a problem. You're accumulating days, 1 week, 2 week. You want to get out before it hits the 6-month mark or 180 days. Next time you want to enter the United States, it's probably better to get a new visa because CBP might not let you in. And at that interview with the embassy, make sure to have your approval notice that shows that although the I-539 was approved for a previous day in 2020 and you didn't get approved, but you got approved in 2022 and it was pending all that time, so you did not accrue unlawful presence days. But it's problematic because just as this lawyer that you're telling me about made a mistake and didn't understand this regulation, a lot of people in the government don't either. You might go to the embassy, you might go to port of entry, you might deal with USCIS later, and they may accuse you of this. But it's a clear policy decision. There's a policy memo that was published, I don't know, about 15, 17 years ago. That really breaks this down. It's 40 pages, very complicated, but good lawyers know that memo really well. 3 or 10-year bar waiver, memo. It's very important to know as an immigration lawyer. But you have to see your paperwork. But if it was pending, you're not accumulating lawful presence while it's pending. Now, once the decision is made, you're accumulating unlawful presence. So you got to be careful for that and get out as soon as possible, unless you got other system going on. And thank you for your question. It's a very good one. Jordan, one of our regulars, says, "Hey, Sir John, if I came on an M1 visa, then expired, but I have a valid tourist visa I applied for a few years ago, will I automatically transfer the tourist visa and not be out of status?" No, that's not it at all. If you're in the United States and one visa status expires, you have to request a change of status to the other category. Your previous tourist visa approval won't make a difference there. Or you leave the United States and you re-enter with a new valid visa if they have a tourist visa with that one. But there's no automatic changes. You're accumulating unlawful presence days, what the previous question was talking about. Once your M1 ended, and M1s, they're not DS, duration of status, so it might be different, but I think they're fixed time. Immigration lawyers usually don't deal with M1s as often. It's very rare that I'll deal with one. M1s are vocational students. F1s are different. Regular students, and we deal with that more. But yeah, be careful. Don't accrue unlawful presence days, and there's no automatic transfer from one to the other. Okay, so next question, Mohammed asks, I'm a U.S. citizen living in the U.S. I applied for the I-130 for my wife about 2 months ago by mail. Our case number starts with the IOE, does not match with any of those USCIS centers. Is that normal? Yes, you've asked this question before, Mohammed. IOE just represents that they put it in the online system. You can check the bottom left of your receipt notice. That's the last location that had your case. It may change in between. We don't know where it is really until you get the approval notice. But that's that. The IOE just represents that they put in the online system, which is a new thing they're developing with USCIS. Okay, Firefight says, can you refuse a chest x-ray at a medical exam because of breast cancer history? No, you got to do the chest x-ray. If you have to do a chest x-ray, you have to do it. I'm not sure if there's a waiver for it. There was a situation that came up where we had a client who was pregnant, and I didn't want to do it, so I researched it, and they said, well, we can do if you're pregnant is they can hold off and push the case back for getting until the baby's born, then do the chest x-ray, but you got to do it. Whether you'll be able to fully waive it, I don't know. It hasn't come up. There's a waiver form called I-601, and you can request waiver of certain medical reasons. I doubt they'll waive the chest x-ray, but first of all, it's not something I've done, so I have to research it. I don't know 100%. Potentially, you can waive it with the waiver, but it's so much work and it's so expensive and so unreliable. I wouldn't rely on that happening. That's something you got to talk to the immigration or private, do some more research on such a unique issue. In the past, my clients who didn't want to do chest x-ray just gave in because they had to, or they waited until the baby was born, for example, and then did the chest x-ray. And that's how I really solve the solution. I'm not fully sure if you could fully waive the chest x-ray if you have a false positive or positive for tuberculosis. Now they ask, hi, John, my boyfriend's Canadian. I'm a U.S. citizen looking to get married soon. Not sure the best route to take to get him here the fastest. I-130, question mark. Also, would love to have a free consultation? Well, Natalie, thank you for your message. if my assistant names somebody who may do it, but the first thing you should do is download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. Almost all your answers will be in there, answers to your questions. So check it out, marriageimmigrationlaw.com. And that's maybe if an assistant names a person, because we already had the first raffle winner, Secret, also Dunia Colombiana. One of the first questions we had about lawful presence, already won the first raffle, for what my assistant tells me. But hey, stay in the game. We'll see what happens, Natalie. But for Secrets, I'll just sign up for the free video consultation. Take a screenshot of where you're watching this and email it to me so I can see your username and I know it's you. And we can schedule a free 50-minute consultation for those watching live. Just like and subscribe, ask a good question, and my assistant will randomly pick somebody in 10 minutes and 20 minutes to give away the free video consultations. If you've been watching, you may have another chance, so keep an eye out, and you might get a chance to get a free consultation. SMS, hi John, how common is a DS-5535 sent to applicants at or after a visa interview? Is this something to be worried about for a K-1 visitor? Thank you. No, it's not something to be worried about. How common is it? Well, if you're from South Asia and the Middle East, it's pretty common. If you're not from there, it's uncommon. From what I've seen, I don't do every case in every country in the world, but I deal with the DS-5535. It's an extra questionnaire that asks about brothers and sisters and a lot more personal information above and beyond what was asked in the initial green card application for an immigrant visa. So it's not something you're worried about, but what's going to happen is your case is going to take forever to get approved, if it's going to get approved. So you can expect a long delay. That's what you should worry about, that part. If it takes too long, you should look into filing a lawsuit. But that's that. Adnan asked F2A, does embassy schedule interview for documentary qualified date or priority date? The embassy schedules cases based on the both of these. So priority date is the case you submit the case. If your case is current, then it's current. If there's the backlog for your case time has to move forward based on your priority date until it's time close to the interview, and then they'll do it. So that's one. But you have to be documentary qualified first before they'll schedule an interview. So it does both. It's both of those are requirements for the embassy scheduling interview. Your place in line has to be there, and once your place is there, you have to have submitted the prerequisite documents to be able to get the interview. Rope asks, hey, attorney, can an immigrant with an EAD can get a CDL? Okay, so you're asking if you have a work permit, can you get a driver's license? Yes, you can. Now, the issue that pops up is you go to the DMV, the Department of Motor Vehicle, they call it different things in different states, and they have a system that's connected with USCIS. I forgot it's called SAVE or something like that, SAVE, but it's some sort of system. And USCIS doesn't always update that system, or the DMV system doesn't always talk to it. So I've had clients who have green cards, who have work permits, should be able to get a driver's license, or at least apply for one. But the system that they have there says, no, we don't show that you have a valid work permit. You go, look here, it's a work permit in my hand, look at it. Or is it a green card? Like, no, our system doesn't show it. And they have a phone number you can call, a website, but it's really difficult to fix it when that happens. So that issue does pop up. But generally, if you have a work permit, most DMVs, based on the standard operating procedure, will approve it usually up until the time of validity of the work permit. Anna asks, is it necessary to have absolutely all tax returns filed before you apply for citizenship? Yes, I mean, you're supposed to have filed. It's a violation of sorts if you don't file your taxes. So on the form N400, the application for naturalization, there's a question that says, have you filed all the federal, state, and local taxes that you're required to do? So you have to say yes. If you say no, they could ask you for those filings or deny your case and the like. So you need to take care of all the taxes, Anna. 29 Super Senior Regulars, good to see you. Says, good night, Attorney Khosravi. Merry Christmas to you and your family and your staff. Thank you so much for everything last year. God bless you. God bless you too, 29 Super Senior Regular Watcher, got his green card. Thank you. I was so happy to be able to help you through this process. Marlon Samuel is another regular. Hi, blessings, John. Same to you. I called USCIS and got my receipt number, but they still haven't mailed the hard copy. Should I worry about that? Marlon, I don't remember all the details of your case. If you haven't received your documents, go to USCIS.gov, and then there's an option within there to say I haven't got my documents and re-request it. It's better you have the documents. Whether you worry or not, maybe not be a big deal, but you got to follow up. Just make sure you have your receipts and you can get your paperwork. It's being mailed to the right place. That's an important part of it. So keep an eye out on that. Bobby asks, hi, John. Hope you're doing well. Thank you. My case is CR1. This is a relatively new marriage person who's married relatively recently, is fine for green card. I applied for my wife in Iran. I got documented qualified 20 years ago. Realistically, and based on experience and data that you have, how long will it take for my wife to get an interview in Abu Dhabi? At least an estimated range time? Unfortunately, 20 to 24 months, so almost 2 years. Abu Dhabi is not a good embassy to have your green card scheduled right now because of the crazy timeline. So that could change. They could double up staff, and all of a sudden this changes. But from 2 or 3 months ago, last person I heard who got one there, it takes about 2 years, so it's not good. Melvin asks, hi, good to catch up with you. Wonderful teachings today. Please, what does it mean when USCIS says your case has been transferred to the visa center for visa processing? I'm assuming, and I don't know if it's your paperwork, but it means you had an I-130 or an I-140 approved, and they transfer your case to the National Visa Center for the next step of processing. It's called consular processing, for you to be able to get the immigrant visa. That's probably what it means. But I haven't seen your case. Can't say for sure. Paul Brown says, does a job verification letter have to be addressed to USCIS, or could it be to whom it may concern? It could be who it may concern. It doesn't matter. This is in contest, I believe, for an affidavit of support where you're going to show that you work and make money. The letter is all about having the letterhead and the contact information of the person signing the letter, along with the necessary information about the background, the job title, when they work there, how many hours they work full-time, how much they make, all this kind of stuff. But I haven't sent job verification letters as part of an affidavit of I-64 in years. What we do is get pay stubs. Just get the most recent pay stubs. That in and of itself is proof in the pudding. So that's what we do. Don't bother the employer unless you really have to. BK Pontas, entered with a tourist visa and married after 2 months. Is it a violation of any laws like the 90-day rule? Is my return ticket helpful to prove my intention? So, typically it's not an issue if you marry a U.S. citizen. If you marry a green card holder, maybe it will. It's probably not. It's more about when you file it, but even then, I haven't seen it be an issue. The 90-day rule is something you'll find online, and the embassy system has that in place. So if you have to do consular processing, they can hassle you about it there. Probably not, but it could happen. If you're working with USCIS, it typically doesn't come up, especially if you're married to a U.S. citizen. Do I need now? Really quick thing. When people ask about timelines and stuff, a lot of times we skip it because we have so many questions about timelines and stuff. A lot of times there's no answer on how long things going to take. Mama follows up: do I need to stay in the U.S. when she is going to the embassy for the interview, or can I travel with her? You can do whatever you want. Most embassies do not let the spouse enter the embassy with them. Sometimes they will. I've seen their website says they won't, but I've randomly seen Australia and Armenia even didn't allow the U.S. spouse to go there. It's up to you if you want to go, but you can do whatever you want to do. Quick question on Instagram. Woman talking fast and throat's getting away. Happy Patel says, we applied for a green card I-485 almost 19 months ago. How much long does it take? There's no answer to that. Hopefully it's fast, but it take forever. Next question. Lamar asks, I have a girlfriend in the U.S. and I have a tourist visa. Can we get married 8 months after I come to the United States? It's up to you if you want to get married. If you have a tourist visa are 6 months. So I'm not sure why the 8-month number comes up. But can you get married? Yeah, you get married. Now, there's a lot more questions for question 2, 3, 4, 5, 6, and after that about the green card and stuff. That's a longer conversation you got to have with an immigration attorney. Download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com, www.marriageimmigrationlaw.com, and learn about it and schedule a time because it's just a lot more going on there, I bet. Elizabeth asks, if me and my fiance have 2 children, will that make the K-1 visa faster? No, probably not. What you're thinking about is it's more proof that you're really a couple. But in practice, it's not about them believing you're a couple or not. It's just they're so backed up. It takes like a year for them to even look at your file. That's really what's happening. So having children itself doesn't matter. I have people. I just had a case approved fast with no interview, adjustment of status, and they didn't have that many documents. I was surprised they approved them without even an interview. So it's just so inconsistent. I wouldn't rely on that happening. Nathaniel says, can you explain the I-212 waiver? So there are different kind of waivers. The 212 waiver comes into place when you have certain bars in the past that you need to get forgiveness for, and or you need to help waive a bar for a non-immigrant visa purpose. So the short explanation is it's a waiver of having previous bars or violations that prevent you from getting a visa. And I'll leave it as that because these waivers are larger conversations that need more facts and stuff. Quickly, I want to announce our second winner, Lizbeth Carrera. We just talked right now about the Fiance visa. My wonderful assistant, Katrina, just named you as our second raffle winner. So just take a screenshot of where you're watching this and email it to me at info@jqqlaw.com. We have a quick chat about your case. Again, just take a screenshot. Let me see your name, and we'll do that. For those just tuning into the live show, we give away free video consultations. We have one more left in 10 minutes. All you got to do is take a like and subscribe and then write a good question or write consultation or something like that. And my wonderful assistant Katrina will randomly pick somebody and name it off behind the scenes, and I'll just name it here. But having said that, let's jump back into the questions. Mehmood says, if a student, F1 student has a criminal case running, can they apply OPT or H1B? They can apply for both, but eventually they may get denied or they may lose status. Okay, so if you have an F1 student visa, you have a criminal case pending, you may get a notice from the embassy that your visa has been canceled, but your status is still good until a decision is made, you're convicted or something like that. When you file for OPT, OPT is a work permission for a year. There's no question, I don't believe, on the I-765 application about criminal history. And the H-1B application, if you're doing change of status, there's no question there. So they're not going to catch on to it. However, if you are convicted of a special crime that's, it's going to lead to removability, you will get a letter to appear in court for deportation. But those particular forms don't ask about criminal history. So you may, kind of get through it unannounced. Masila says, can I mail my medical exam with application for adjustment of status based on a marriage US in order to attempt to get the interview waived? Having the medical exam there has no effect on getting it waived. We're getting marriage green card waivers every week now, and all of them, they just say, send us the medical checkup and get a waiver. So it has no bearing. Secondly, you do not want to, on your own, just submit stuff to USCIS. That's not a good thing. You gotta wait for them to send you an RFE, so it's in their record that they're getting a document back from you. Sending it there without that, there's a good chance your stuff's gonna get lost and you have to do a new medical. And so don't think that having a medical is gonna cost a waiver as opposed to not having one. They're not related. Annika Sifals, hello, husband missed his tax return 2016. Does it affect citizenship? Yeah, it can, because he didn't file it. So if he was supposed to file his tax in 2016, he should go back, file, and pay any back taxes, so he could honestly answer the question for for citizenship purposes. Andrea Soto says, very good information. Thank you. Radhika says, does USCIS fix the naturalization of citizenship marital status? Naturalization of citizenship marital status. I'm not sure what that question means. Naturalization of citizenship, marital status. I don't know what the question means. Sorry. Zaid asked, my case was refused on a 221G for lack of documents. I submitted lack documents. How long does it take to be issued? There's no timeline, however long they want to take. Freddie asked, any news about DACA? No new updates happening right now about DACA. Matter of fact, asked, we filed the marriage-based green card. My spouse is abusive. Can I wait for an interview or separate? This is a longer kind of question. There's a thing called the Violence Against Women's Act. It doesn't have to be a man or woman for that, but if your spouse is being abusive, like you can still get a green card even if you separate or not together and stuff like that. So definitely, email my office, schedule a consultation. We get to talk about that for a VAWA case if your spouse is abusive. Right now it's a little bit backed up. It'll take some time, but it's if there's real abuse and you have evidence and you can prove it or talk about it, there's a good chance you'll get your green card. Sorry that you have to go through that abuse. Marlon says, thank you, you're welcome. B Black says, will they send an EAD, a work permit, before the I-485 is approved, filed on March 22? Sometimes they do, sometimes they don't. Sometimes your green card case is approved before they get around to approving the work permit, and the green card is a work permit too, so they won't even send the EAD. So there's no fixed thing. Sometimes it is, sometimes it does come, sometimes it doesn't. Quick question on Instagram. Two says, I submitted my motion to reopen a year ago in December last year. How long does it take for them to reopen? There's no fixed times on these, unfortunately. That's why a lot of time appealing is an iffy thing, because you never know how long it's going to take. Paul Brown asks, I was told I could still receive a work permit despite receiving an RFE regarding joint sponsor. Is there any truth to this process, or is it stalled? I've had colleagues tell me if you get an RFE, they're going to pause the work permit as well. But randomly, I've gotten cases get work permits even with an RFE. They could have been an exception, or they forgot about it or something like that. I've never been able to find an official answer to that question. Allah saying, one of our regulars says, "Hi John, how long does it usually take the embassy to schedule an interview after all documents?" I was saying, because you're right. Usually I don't answer this question because you're a regular. I will, but if you're a regular, there's no timeline. Depends on the embassy and whenever they get around to it. Lucy asks, how many tax returns with citizenship application? Every tax return you're supposed to file has to be a file. Melvin says, my case is an I-130 from which now says case has accepted visa center processing. What does it mean? So if your I-130 petition has been approved and the person getting the green card lives overseas, they're transferring the case now to the National Visa Center as part of the Department of State for you to start consular processing. Download the Ultimate Marriage Green Card Guide, even if you're not a marriage case. It talks about consular processing. I have a really, really in-depth video on consular processing. It answers 99% of questions about it, or maybe say 90%. Just go to JK Law, just search JQK Law consular processing at YouTube. 20-minute video breaks down every aspect of it. It really is going to talk. So it seems like you need that information. Then if you want to have a consultation or a lawyer with you, just email my office. We'll schedule a consult. Secrets follows up. My husband filed the I-130 for me, but to adjust status in U.S. Now I have to leave. Is it better to file do I-130 consular processing or do I-24? Let's talk about that probably because if you leaving is a mess, I don't recommend doing that. It could cause problems. But which is better? So one is file the new I-1. Maybe I can't. You're not my client, so I can't give you. This is too in depth. But things you would think about is maybe filing new I-130. Let the previous one still go to approval, and then do an I-24 once approved, because you can't do an I-24 on a pending I-130. It has to be approved first. and probably filing new I-130 is best. But it's a tricky situation leaving. You could have problems with the embassy later, depending on your background and stuff like that. So that's something you want to schedule a private consultation with a lawyer. We're going to chat about it really quickly. John says, hello, buddy. Please, what's the chance of getting a marriage green card after getting denial and the issue was fixed and refiled? Many thanks. The question is impossible to ask. What are the chances? Like, I don't know anything about your case and why it was denied. And it's not a chances thing. Either you have a good case and you give it a shot, or you don't. And don't look at it like, what are the chances? That's impossible to answer. CE user, one regular, says, when is the best time to file the medical for the I-693 adjustment status upon filing or when asked by USCIS? Also, I-64 parent U.S. citizen case. If you're doing a parent of U.S. citizen case, it's better to do it before filing. For marriage cases, I typically do it later. It kind of depends on how much more practically. Some people need to get their case in as fast as possible. For example, the form is being updated on December 23rd, the I-485 form. And so we don't, some cases it's easier not to use the updated form on the current one. And so we had one case, we don't have time for him to get the medical. We would have submitted with the medical, but we don't have time. So we're going to submit and get the medical later. So it's more of a practical thing of what's going on in your case. Because clients sometimes take forever to do stuff, like I'll say, get the medical, like we have the case ready, we need to file it, and they haven't even gone around to schedule an appointment. And when they do call the doctor says come in 2 months. And it's like, okay, well, let's just get the case in and deal with it later. So it's more about practical aspects of which you want to do it. Or we have cases where people do the medical checkup and then they take forever to give us the rest of the documents. And right now there's an exception for COVID, but typically the medical checkup will be valid for 60 days before filing. So it takes so long that the thing expires. So again, it's case by case basis based on the practical necessities of that case. Questioner asked, do I have to renew my work permit if my asylum approved and my green card is pending? Yeah. You don't want to, let's see. I think for asylum, I don't handle asylum cases for many years, so I don't remember all the rules for asylum. I think asylum on its own has work authorization. I don't know. It's better to renew it. What you should have done is file for a green card with the green card application. Do you have to? You don't have to do anything. But if you want to work, it's about the work permit. But I don't remember if asylum regulations that if you're approved asylum, you can work without work permit or not. Can't remember the rules on that. Azim, what are regulars? Other day you said no stamp for visitor visas. What if they don't register? Weird policy. They've changed this policy. They're going to stop stamping people coming at the airports because it's faster, so there's less time stamping everyone's stuff. I don't know what you mean if you don't register. I don't know what that means, but the officer should, put you in the system. If it doesn't come up, that comes issue. Sometimes, they might not properly put you in the system. You have no proof that you entered lawfully. It becomes a headache. This happens a lot at the land board, especially from Mexico or from Canada coming in where they don't stamp. They have no proof. It becomes problematic. But that's, it's a problem that can happen. Daryl Winterbaugh says, hi. Hello, Daryl. Got to see you. Paul says, Scorpio asks, my biological dad is an American citizen. Can I apply for citizenship? I don't know. I don't know enough about you. And the fact you say my biological dad, I got to see what's going on and about your family stuff. So there's a lot of analysis that has to happen to be able to answer that. Really quick, I do want to announce our winner for our third raffle, CE user. If you're still watching, take a screenshot of where you're watching this and email to me at info@jqklaw.com, and we can schedule a private video consultation. Yeah, let's take 1 or 2 more questions and call it a day. Lisi says, when the I-61 is approved, you receive an approval letter through mail or the consulate? You get it through the mail. USCIS sends it to you. BK Pond says, recently got an RFE. We have both individual and joint bank accounts. Should we only send joint bank account information since it is relative to our case? Is it detrimental to individual? I don't know what the RFE is for. Normally, the RFE, they don't ask for, like, if they don't believe your relationship, they want more bona fide documents, you send the joint documents. But if it's an affidavit of support, they may need to see all the documents. So I don't know what the RFE is for, so I can't really answer that. Zaid says, thank you. And let's see, one more question. I was saying, can you invite your law while spouse waiting for visa interview? Your in-laws, maybe. There's no invitations. Anyone can file for a tourist visa. They may or may not, they may not approve it, so just got to see. Having said that, thank you everyone for joining. Sorry, I got to go. Throat's giving away. We'll be back again next Tuesday. Might have an hour session next Tuesday with my associate, so it might be fun. We'll change it up a little bit. But having said that, happy holiday season, everybody. We'll be back next Tuesday, 5 p.m. Pacific time. And that's about it. If you want to schedule a private consultation, email the office and we set that up. Until next one, God bless. Be safe. See you soon.